Hello everyone, my name is Jacoby Perez with Jurasi Litigation, and I'm going to talk today about preliminary injunctions and how they affect your non-judicial foreclosure sale. So you're a lender and your borrower defaults. You file the notice of default, you file the notice of trustee sale, you make sure all the timelines are up to statute, you make sure all the wording is up to code, and you have your trustee sale on the horizon. Now you're still not necessarily in the clear, as there are certain things that borrowers can do to try and stay that foreclosure sale. The one we're talking about today is moving for a preliminary injunction. And that's a big one because if that injunction gets issued, it may well stay the sale for the duration of litigation. Anyone that's been involved with litigation knows you could be talking about having your money tied up for months, maybe even years. So the borrower will file a complaint and get a case number issued. Then they'll file their motion, typically in the form of what's called an ex parte application, seeking a temporary restraining order and requesting that the court set a hearing on what's called an order to show cause regarding whether the preliminary injunction should issue. The court will be looking at, in these ex parte applications, which are emergency motions generally heard on 24-hour notice, whether the borrower proves a likelihood of prevailing and whether the borrower will suffer irreparable harm should the injunction not issue. Now, the borrower has the upper hand in these motions, given that they've had months to prepare all of their documents, while you have less than 24-hour notice to get an opposition on file. Should you not prevail at the TRO hearing, it's not the end of the world. The nice thing is these temporary restraining order hearings, or these temporary restraining orders, are just that, temporary. The court will issue a 15-day restraining order that will restrain the sale, the trustee sale, from going forward, and then set that injunction hearing shortly thereafter, that 15 days. That preliminary injunction hearing, now that's the big one. You'll have not a lot of time, but a short window in order to gather your evidence, talk to your attorneys, get your evidence together, including declarations and documents, to hopefully prevail and prevent that injunction from going forward. That's why you need experienced, capable attorneys familiar with the process, and that's exactly what we do at the Jurasi Litigation Department. Thank you.